Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. How are you enjoying your morning so far?
I love it.
You love it?
Yes, I'm riding high off of my coffee and nothing bad has happened yet. So
That's a good sign.
Absolutely.
Okay, so, we've talked about conservatorships and limited conservatorships, but what are the different types of conservatorships?
Okay, actually, there are three different types of conservatorships in general. There's what's called a general probate conservatorship. Those are for individuals who may be suffering from age-related dementia or some sort of traumatic brain injury, and they're adults. And for those issues, they are no longer able to make their decisions, so someone is appointed. A limited conservatorship is something that the court can appoint over someone who has a developmental disability. So that a developmental disability is, generally speaking, something that manifests itself either at birth or shortly thereafter, prior to the age of 18. Anecdotally, this includes intellectual disability, cerebral palsy, epilepsy, and autism. Generally speaking, candidates for limited conservatorship would be clients of the regional center. And then there are what are called LPS Conservatorships. Those are conservatorships for individuals who do not have a developmental disability, or actually the purpose of the conservatorship is not to address a developmental disability. And it's not really for individuals who have some sort of cognitive or intellectual impairment due to dementia or Alzheimer's. It's for the mentally ill. That's a harsh term, but it's something that relates to a mental health condition in which the individual poses a risk to themselves or others. Anecdotally, someone who may have been under a number of involuntary holds, 72-hour holds, they're also known as 5150 holds. Those are the type of scenarios in which a LPS conservatorship may be initiated. So you have those three different types of conservatorships, and we're kind of focusing on limited conservatorships today. So what I want to illustrate, I'm going to sort of push the LPS conservatorships off to the side. So a general probate conservatorship is a conservatorship which pretty much takes away all but a few rights of the conservatee. This person cannot understand their decisions or understand or appreciate the consequences of their decisions. So someone comes in, files a petition for a general conservatorship, and gets to make all of the personal or financial decisions. The personal decisions would relate to where they get to live, withholding informed consent for medical treatment, and so on. So if you were to look at it ideologically, a general conservatorship is to provide the maximum amount of protection for someone who needs protection. A limited conservatorship is something that was kind of born out of the 70s, in which the court and the legislature recognized that there are these individuals that have developmental disabilities, and their level of impairment can fall within a very wide range, from mild impairment to severe. It could be someone who can't really understand some of the more sophisticated decisions that are required to live a long and productive life. And it can go all the way to individuals who are just nonverbal. So the court and the legislature very much respects that individuals can fall within this very wide range of abilities and impairments. So the attitude for the limited conservatorship is one in which it is a protective proceeding, but it is designed to assist the limited conservatee, the individual with the developmental disability, to lead a productive life that is close to normal as possible. So in the in the general conservatorship, like I said, the court essentially takes away all but a few powers, while the limited conservatorship has a more measured approach in which there are 7 powers, and you as the conservator can be empowered with 1, 2, 3, 4, 5, 6, or 7 of these powers, depending on what is appropriate for the situation. Now I have a list here of the powers, and I'll just spell them out specifically. So if you have a developmentally disabled child, short of telling you what to do, I would say that you should consider the limited conservatorship, and you should think carefully as to which powers to ask for, because every power you ask for is a power you're taking away from your child. Mm-hmm. So there are what are called the 5 standard powers, and then there are the 2 additional powers. It varies from county to county. Each county and each court has their own attitude. I mean, even each bench officer may have their own attitude towards what powers to give and what powers to take away. So in some counties, if someone is of sufficient impairment, they say, okay, well, this person's clearly impaired. I'm going to award you all 7 powers. Let's be safe. In other counties, they take a much more protective attitude towards the limited conservatee and say, well, I'll give you the standard 5 powers. And if you want those 2 additional powers, I don't really think you're going to need it, but if you want those 2 additional powers, you're going to have to go to trial over it and prove it up. I'm not going to rubber stamp this. Not that the court rubber stamps anything, but I'm not going to just approve this without some sort of evidence being taken. So of the 5 standard powers, there's the power to control residence. In short, to determine where the limited conservatee gets to live, whether that person gets to live at home with their parents, or whether that person gets to live in a group home, and everywhere in between. Another power is the power to have access to the limited conservatee's confidential records. Everyone has a right to have access to their confidential records and to have no one else have access to them. So this is an additional power that will be given to the conservator and taken away from the conservatee. The third is the right to contract. So a limited conservatee that is verbal and high functioning may really like that cherry red Camaro Z28 that they saw at CarMax, and but doesn't quite understand or appreciate the legal ramifications, or more likely the financial ramifications of doing a sign and drive transaction. So that is a power that can be taken away from the limited conservatee and given to the conservator. Another one is the ability to give or withhold informed consent to medical treatment. And the 5th is to make decisions as it relates to the limited conservatee's educational needs. So this limited conservatee, now 18, may be transitioning out of high school and may wish to go to college, or may wish that they don't want to go to college, or may wish to pursue educational endeavors through workshops. The conservator, which in this case I'll just use the parent, would have a great deal of contextual history and knowledge as to what is the best approach for this limited conservatee's education moving forward. So that is the 5th power. The last 2, like I said, some courts just say, well, fair enough, we're going to give you all 7. And some courts, the public defender or the court-appointed counsel will object, or the regional center for that county will say, we're very wary on giving these last 2 powers. That is the right to marry, and that is the right to control social and sexual contacts. So some courts staunchly, or some, I would say, regions would say, well, those are kind of very sensitive powers, and we're going to want some more prior to awarding them and thereby taking them away from the limited conservatee. So you should always talk to your attorney and know where you're at in terms of what county you're in, and discuss as to whether or not there is a special circumstance which would warrant the awarding of those last two powers.
Okay, well, thank you very much.
Thank you.
If you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.